Good morning, everyone. Thank you for joining our webinar today. The topic for the day is when should a scheme consider administration? Our two speakers for the day are Willie Roos and Veronica Bengu. Okay, I'll just do a quick intro for those of you who don't know Willie. Willie has practiced as a property attorney for over 20 years. He was involved in sectional title management for over 8 years, where he dealt with various municipal bills and interacted extensively with local municipalities. Willie started Stratafin in 2014 with the goal of assisting bodies corporate with their funding without catching them in a debt trap. Stratafin strives to be a fair and equitable money provider for the sectional title industry. Veronica Bengu. Veronica studied at Northwest University, Vaal and Potchefstroom campus, respectively holds a BA law degree and an LLB degree. She's completed her articles of clerkship and is admitted as an attorney of the High Court. Veronica is well versed in sectional title and homeowners association legal compliance. Veronica sees herself as a pioneer in the community scheme industry, speaking at various NAMA events, educating the industry on administration in terms of Section 16 of the SMA. Veronica was appointed as Director of Confiance Administrative Solutions in February 2022, where she administers sectional title buildings in distress and has had huge success so far. Thank you very much. I'll leave it to you, Veronica.
Thank you, Lauren. Thank you, Lauren.
Thanks, Lauren. Let me just jump in here, Veronica, before you start. And I just want to also, from our point of view, or from us, say thank you for assisting us today or being here with us today to do the talk on administrations. You are running Confiance Administrative Solutions, and you've done so successfully for the last 2 years, and you've assisted many schemes with huge problems. And we're going to enjoy listening to you. I'm going to chip in here and there where I want to have certain further information from you, but over to you. Thanks, Veronica.
Oh, thank you. Thank you so much, Willie, for the invitation and the opportunity to have this discussion with yourself and your attendees. I know you've got a huge audience in the sectional title industry, and I think most importantly, it's a privilege to be on this platform and to have this discussion. So yeah, thank you. Our topic today is when should a scheme consider administration? And we've grouped these into 4 or more like telltale signs, and we're going to break down what each telltale sign actually means. So we see a lot of schemes. So firstly, schemes are placed under administration for various reasons. So you won't have 2 schemes that will have the same symptoms, which leads to them being placed under administration. But there are some common denominators in most schemes that are under administration, and we're just going to be discussing the common denominators. Then first of all, we see in most schemes there's non-compliance with the Sectional Title Schemes Management Act, and we see that these schemes are not holding their AGMs or their annual general meetings as prescribed by the legislation. The financial statements of the scheme are not being audited as required by the prescribed management rules, and there isn't sufficient budgeting that is done in terms of the Sectional Title Schemes Management Act. And these 3 things can look very minor, but in the bigger scheme of things can cause trouble. So if you're not having annual general meetings, so you're not discussing or approving a budget, you're not approving your annual financial statements, you're not approving your 10-year maintenance plan, you are falling behind. If this is happening for consecutive years, so the scheme then falls behind, and there are some schemes that have fallen so far behind that they aren't able to catch up. And this manifests in having a budget that is outdated 4 or 5 years. So the budget that was approved 4 or 5 years can no longer cover the expenses of the scheme. So the scheme is then under recovering. So those are the issues of non-compliance with the Sectional Title Schemes Management Act that might seem minor, but over time, or even skipping just 2 years or 3 years, can leave the scheme in a very precarious position.
Veronica,
Yes.
Out of your experience, what have you seen happens? So what is the effect eventually of those AGMs that are not held, budgets that are not approved, and so forth? What in practice, what have you seen at the end? What resulted at schemes when this didn't happen?
It results in a scheme living in a previous time, if I can so to speak, because the scheme is relying on the financials or the budget that was done whenever last they had an AGM. So that budget that was approved, say maybe it's now 3-4 years later, they haven't had an AGM to approve an updated budget which will cover for the expenses of the scheme. They don't know what the financial position of the scheme is because the audits have not been done. They haven't had AGM, so they might be sitting with a board of trustees that is now 4 years into its tenure. And these problems manifest in you having an outdated budget. So you're living 4 years ago and you're still covering for expenses that were 4 years ago, and you're under recovering because prices increase. Your garden company that cost 1,500 Rand per month 4 years ago is not going to cost the same in the current year. So you have an under recovery problem. You don't know what the financial situation of the scheme is because you haven't had your audits done and the audits have not been audited. So everyone is kind of like in a haze to what is the actual reality of the scheme. Then with AGMs, there are a lot of business that needs to be discussed at AGMs, like the approval of the budgets, the approval of the AGM. You need to elect a board of trustees. You need to discuss any other special matters. So if you're not having this meeting, the scheme is kind of like living in limbo or floating along. So it kind of leaves the scheme in a previous time where those things were done. But obviously, these need to be held every single year so that they are updated and keep relevant with the situation of the scheme.
I know that Stratafin is often being asked to assist, and then we see from our point of view, once we start analyzing those schemes, then we see that they haven't paid municipal bills for numerous of years or months, huge amounts of outstanding amounts. Have you seen the same type of things?
100%, which goes to the second reason, which is on the next slide. If you can just go to the next slide, Lauren, which is the financial issues that the scheme has. The financial distress. This will be very, very prevalent in the financial distress of the scheme. Like you said, municipal bills that are outstanding. We've seen amongst us municipal bills in the 20 millions, 23 millions that are outstanding. And this could result in a numerous amount of reasons that Confiance has the skill to detect and assist. But you also see schemes that are in distress because of their owners not paying their levies. And if you're not having AGMs, for example, or auditing your financials, you can't see the reality of this situation. You see schemes that don't have any legal collections in place. So yes, they have this huge outstanding debtors book, but they have no mechanism to collect it, which becomes problematic. And if it's gone for long and ignored, it has an extremely dire effect on the scheme. You see schemes that are owing their creditors. You see body corporates that are within an HOA and they're owing the HOA levies. You see them owing their gardening services, their maintenance, pool maintenance people, their employees sometimes. So you see schemes that don't have a 10-year maintenance plan, like I discussed in the AGM. This is something that must be discussed and approved. So if a scheme is not having AGMs, so it rolls over to say that they don't have an approved maintenance plan. And you also see that they don't have the funds for maintenance plan because they haven't adequately budgeted for it in terms of the Sectional Title Schemes Management Act. So you also see the financial distress creeping in there, and that's when owners and trustees should consider placing the scheme under administration when these signs are there and there's no management of these signs. Yeah.
So the other thing that we also see, and I speak about it a lot, is when you do a budget, you need to, for example, budget for legal fees, because we know that legal fees are not recoverable now directly from the owner in total, and that you can only recover once you've taxed it or the owner has agreed to it. But we also see that many schemes where all these symptoms manifest, you see that they don't have money to actually do collections. So at the end of the
100%.
day, they can't appoint attorneys, or they appoint attorneys that just work on a contingency fee basis, and those matters are always left to the last on an attorney's table because he's not getting paid for it.
Paid. Yeah.
So that is that I would think you guys get as well on your side, where you will then see that there's no collections that are taking place.
100%, and that's where the bulk of the problem actually comes, because and I'll always say this, is that the lifeline of a scheme, it's its collections. So if a scheme is unable to collect, it's most likely unable to fulfill most of its obligations in terms of the Sectional Title Schemes Management Act. And the Act does require that the trustees, or the body corporate rather, collect the arrears from the owners that are indebted to the scheme. So if a scheme is not planning for the collection of these arrears, then it kind of goes on into perpetuity. And we see a huge problem when we have units, or we have a scheme that has an outstanding debtors book individually of an amount that is exceeding the value of the property. And that's where the big A now comes in. So these problems, like an outstanding debtors book, cannot be left. A plan needs to be devised for the scheme to be able to collect this. And this is what we also do at Confiance, is we make sure that we have a legal collections mechanism in place, because we understand that the lifeline of the scheme is the payment of levies.
You've also touched something there where you said where your outstanding levies exceed the value of your units. So that becomes a huge problem. I mean, we are contacted by schemes that want us to assist them in respect of their levies, and want us to fund them and give them money in respect of levies. And then those outstanding levies exceed the value of the units. And one can never recover more than what the property is worth, because nobody is
100%.
ever going to pay at an auction. As part of the purchase price, you are obligated then to pay for that levy clearance figures. And nobody's going to pay more than what the value is of that unit in respect of clearances. So when a scheme gets to that point, in actual fact, when a scheme gets to about 30 or 35% of value of the units, then you're already getting into a problem, because at the end of the day, that 35% becomes 70% over the period of collection with interest.
100%.
And you're lucky if you get 70% of the value of a unit at an auction. So you already start having a problem if you're getting at that point. Do you see the same?
Yes, 100%. We see debtors, or we see schemes with such a huge outstanding debtors book, that at the end of the recovery period, the body corporate will not be able to collect the whole outstanding debtors book. And then the body corporate then needs to have its books reflect that the body corporate can't collect. And the more serious problem you sit with here is that those levies, or those outstanding debts, is services consumed. So what happens now to, for an example, your municipal debt? How do you service your municipal debt when you can't collect the full outstanding arrears from the owner at auction? So when it gets to that point, it becomes extremely difficult for us to collect the full book. Now we have to be creative in terms of collection, because the city's gonna want its money 100%. They have rendered the service, and they need to collect the outstanding. So that goes into our methodology at Confiance, how we rehabilitate schemes. But I must attest that it becomes extremely difficult situation to recover outstanding debtors book, where the value of the debts is now going above 45% of the value of the property. Yeah.
I want to just throw something in here. I heard you over the radio saying it the other day when you were talking with CISOS or the PPRA, when you were on a radio show, and you were explaining how a scheme that goes under administration doesn't come with a checkbook. Maybe
yes. Yeah. So you see schemes that have all of these problems, and we can also go to the third slide where I'll incorporate the other problems. So you have schemes that are not budgeting. that don't have a 10-year maintenance plan, don't have legal collection mechanism, they don't have funds for the legal collection. And now you're appointed as the administrator, and yes, your mandate in terms of the court order is to rehabilitate the scheme. But all of these issues need money to fix. You need to appoint attorneys. Attorneys cost money. Where's that money going to come from? The administration order doesn't come with a blank check for the administrator to miraculously solve all of the issues. And that's why I said in the beginning that the lifeline of a scheme, whether the scheme is under administration or whether the scheme is with trustees or with an executive managing agent or a managing agent, it comes from the payment of levies. If owners don't pay levies, neither the EMA or the managing agent or the trustees or even the administrator will be enabled to do their task, whichever task that is on the three, whichever end of the spectrum you are on. So it's important for owners to know that, yes, we are the administrator, we are coming in to assist, but we need owners to pay their levies because that's where we're going to get the funding to fix the problems. So unfortunately, there isn't a blank check at the end of the administration order to now go and solve all of the issues. I wish it was. It would make my life a lot more easier, but it is what it is.
I see you deal with lack of leadership and management as a third reason for schemes going under administration. I'm aware of one of the schemes where we assisted, where you guys are also the administrators, where you had two boards of trustees, competing boards of trustees. So maybe you should elaborate a bit on that as well and tell us how that happens. And also two managing agents in actual fact in that matter.
So one of the, and I saw a message here saying, are there any early warning signs? What we are discussing now are early warning signs of a scheme that is going to the route of administration or when it should consider. So listen to this with that ear to say these are the early warning signs. So with that particular scheme, we had two board of trustees who, the one is saying, no, we are elected accordingly. The other one is saying, no, we're not elected accordingly. So the one board goes and appoints their own managing agents, and then the other board sits with their own managing agents. And then obviously there's going to be conflict. The other owners are now in between this infighting. Where do we pay our levies? You pay on this side, your levy statement doesn't reflect that you've paid your levies. You pay on the other side, the one levy statement doesn't reflect. Obviously, decision-making, how is the scheme going to move forward? If they want to paint the boundary wall, for an example, which trustee's resolution is going to be the one that bears weight in that situation? And when you have a situation like this, an administrator comes and to the owners and the trustees, whichever board of trustees is deemed to be the relevant board of trustees or the correctly elected board of trustees. And then the administrator then works to solve the issues. Yes, it would be a resolution to go to CSOS and have CSOS determine who's the legitimate board of trustees. But normally by the time it gets there, there's a lot of damage that has been done that can't be undone. So you have infighting not only between trustees, two boards of trustees, you have infighting within with trustees and developers, you have infighting with and the body corporate is not stood up to go to CSOS, etc. So you do have situations where the lack of the infighting definitely becomes precarious for the scheme, and then the scheme suffers. And then when you see lack of leadership, and I mean to say this, you've had a board of trustees, say maybe for 4 years, there hasn't been an AGM for a new board of trustees to be elected, and the board of trustees is inactive. They're not making any decisions. Any things that are brought to light by owners, any like misalignment with the legislation is not resolved. So you have a board of trustees that's not fulfilling their duties in terms of section 3, 4, and 5 of the Sectional Title Schemes Management Act. So then what are owners to do? Owners can use section 16 of the Sectional Title Scheme Management Act and bring an application to appoint a board, to appoint an administrator, because there you have, the scheme is not moving forward. And we also see this in many of the schemes that approach us to say that Yes, we have a board of trustees, but they're not doing anything. We got disconnected from services from the municipality. Us as owners had to come together and put a deposit together to go submit to the municipality. Yes, we have a board of trustees, but the gate has been broken for months on months on months. We've sent requests. The trustees are not coming through to provide resolutions. So that can also become a huge a pain point for schemes where you have trustees that are duly elected, sitting in the board, but are not making any decisions to propel the scheme forward.
There's another question, and it says, what is the role of a managing agent with new developments where trustees did not receive training? Investment properties are growing in South Africa. The act is lacking in responsibility in respect of managing agents. I think that one of the schemes that you are currently dealing with, and that is a huge bone of contention and which is a huge legal fight, is a brand new scheme in Ilovo in Johannesburg.
Yes,
where there are developer and owner problems, and there are two conflicting sides in respect of that scheme. And the managing agents, I think one of the things that you guys had to do was to rectify all the participation quotas, because the levies were not budgeted or were not allocated in accordance with the participation quotas in such a way that it benefited the developer, even though it was not in the rules. So there was no responsibility on the managing agent, because unfortunately the managing agent is just following instructions from the trustees. The trustees in this instance was appointed by the developer, so he has control over the trustees. So he's actually manipulating the whole development and the implementation of how the scheme should actually come off the ground. He's manipulating that in his favor. So yes, it is a problem. So that is definitely something that needs to be looked at the Act. But I also think that education of managing agents and the education framework that is going to come in place and shortly going to come into place is going to place a larger responsibility on managing agents, because it is professionalizing the industry. And at some stage, one would not be able to say, but I just received instructions and I did what I...
100%.
So definitely professionalization will definitely change things as well, and we hope for the good.
No, I just to add there, I definitely empathize with managing agents that sit in a situation where, yes, they need to follow the instructions. Okay, they are required by the law to follow the instructions of the trustees, or to act on the instruction of the trustees. But I think we would like to see an industry where managing agents are the professionals in the relationship, and they can explain to the trustees what the decisions they are making, the impact of the decisions that they are making, or the lack thereof of the decisions that are not being made. Because yes, you see that the managing agent must follow the instruction of the trustees, but if the trustees are not making any decisions, then what as the managing agent? And I understand you can't slap the hand that feeds you, but also it puts the industry in a loop where you have a board of trustees that are inactive, you have a managing agent that is I don't want to say too scared to say anything, but they're also trying to protect their income, to say, come on guys, wake up. So it would be a great revitalization of the industry to have that relationship professionalized, instead of what we're seeing at the moment, which also leads to the downhill slide of most schemes. And on the education as well, I believe Stratafin also has an educational training portal for all owners. It is a trustees training portal, but it's open for everyone who wants to educate themselves. So I think also taking the leadership and the ownership in yourself as an owner in a scheme to say, I don't want to know more about what decisions need to be made, and you hop on the portal like the one Stratafin has, and you educate yourself.
Absolutely. We also just saw that somebody said, but the managing agent surely must follow what the trustee says. And that is the situation, because it's the
Yes.
master-servant relationship or employer-employee relationship currently. But definitely that needs to change. That is definitely something that we need to professionalize the industry, and the managing agents should become the professionals in respect of what they're doing, and they should take professional responsibility. If I go to
100%.
a brain surgeon, I don't want the brain surgeon to take instructions from my wife how to operate on me.
Imagine how that would end.
Yeah.
But 100%.
Luckily, I'm
yeah.
not
You
married.
can move on to the next slide, Lauren. Yeah. We spoke about the infighting between boards of trustees and the group of owners and developers and trustees. This can definitely cause an issue. And here, this is where you actually need an administrator who's impartial. So you don't have a situation. So another one issue that we find is that owners think that the administrator is employed by the board of trustees or employed by whoever brought the application. No. And I've said this in many consultations when owners come with issues, like the issues we are discussing now, and then they say, but when you come in, you're gonna do what I am saying the problems are. Then I say, no, we are gonna do what's best for the scheme. And what's best for the scheme might not always make you happy or might be the most popular decision, but our mandate is to act in the best interest of the scheme. So you can move on to the next slide, Lauren. Is there anything else, Willie?
No, it's just, again, when the scheme is in financial distress, and the trustees are not performing their duties, should the managing agent inform the owners? The problem at the moment in respect of that is, if you go and inform and you tell on them, then you're going to be dismissed. That's the problem that we set. So it's the serving of two masters. You're actually serving the scheme, but you are reporting to trustees and they can dismiss you. So I've suggested, and it's a suggestion that I've made at many forums with CISAS and the PPRA, in respect of legislative changes, that only owners can appoint and dismiss a managing agent. Because at the end of the day, if the trustees are not fulfilling their duty and the managing agent then informs on them to owners, then the trustees can't dismiss them. So then we will start seeing the change in the relationship. And then the managing agent will be in a position where they can say, but this is how things should be done. And if you don't do it, I'm going to tell the owners that you are not doing it. So maybe that is a start by changing the legislation in that regard. We hope we can move the legislator to make a change to that effect.
Yeah. So the next slide will be dealing with how do you bring a scheme under administration, and this is done by a Section 16 application. So this application, in terms of Section 16, can be brought either by an owner, a judgment creditor, or the municipality. So it's an application that is made either to the magistrate court or the high court. We at Confiance prefer to use the high court route, where in the application we'll then put the reasons that the scheme should be placed under administration. And the reasons would be what we've just discussed now in the past 3 slides. There is no budgeting. There is no annual general meetings, no audited financials. We'll state that there's financial distress, there's an outstanding debtors book. We will say that the scheme owes the municipality. We'll say that the scheme owes its HOA, or it owes its gardening service company, or it owes like 90% of its creditors. We'll also say that there's no legal collection mechanism. So we will put all of the things that the scheme is going through in the application, and then the court will then decide if the scheme needs an administrator, and if the court finds that the scheme does, they will grant the administration order, and if the court finds that the scheme doesn't, they will dismiss the administration order. And in my experience,
Sorry, Veronica. Lauren, you just moved slides. Just remain on the slide first, please.
Shane,
Sorry, Veronica.
Is your slide showing correctly on the previous?
It shows
No,
the
the previous one.
misconceptions, the previous.
Yeah.
Please go back to previous slides. Sorry,
Okay, sorry.
Veronica.
No, sorry, mine is not showing correctly. I'm not sure.
Yeah.
Sorry.
So then the court will then decide if the symptoms that are placed in the administration application are require an administrator, or the court will say, no, the scheme doesn't need an administrator. Now, in the time that I've been an administrator, and it's nearing 3 years now, I've never seen an application that was brought before court that was dismissed, even when it was defended by either a creditor or an owner saying, no, the situation of the scheme is not as was depicted in the application, and the scheme is fine, doesn't need an administrator. Not even in those circumstances have I seen the order being dismissed, or the application being dismissed, or the court saying, no, the scheme doesn't need administrator. So with our applications, they do tend to be successful because we do a due diligence before we actually go through the route of placing the scheme under administration. And some of our clients will say, I tell our clients, and I say, I'm playing the devil's advocate because I'm asking the questions that the court will be asking in terms of this administration application. So that's more or less what is in the administration application. And then with the issue of costs, Willie, do you want to come in there?
Yeah, so in general, the court awards a cost order in favor of the applicant when they do an administration order. So the court will then say that the body corporate is liable for the cost of such an application. So in general, what administrators then would do is where owners applied for this, they would then utilize that as a credit towards the owners. The body corporate would then, in essence, pay the owner back in the sense that the owner will have that credit on their levy account for the period that it requires to actually utilize the amount. So I think that Veronica, I'm aware that your guys that when you start an application, you're looking at about a 25,000 Rand deposit to bring an application in the High Court. So it is quite a financially hefty burden that must be carried. But a proper application is done, and the order specifically states exactly what you guys can do. I'm well aware of that because that order then gives you the authority to actually deal with financial services businesses like us and others in the industry, and to sell the debt, or to obtain levy finance, or to obtain a loan, whatever is required. So I know that all those things sits in the order, and we regularly check that when we assist, that those things are there. So the cost can be substantial, but in general it is recoverable then in respect of the people that brought the application, in the sense that it goes into their levy accounts as a credit that they've afforded. I don't know if there was anything else that you wanted to ask me about the cost. Because we've done so many with you guys when we assisted and so forth.
I think the most common question that we get, and I'm not sure if it's in the chat at the moment, is what is the maximum cost? Because we've seen schemes that the application is not opposed, so the cost won't escalate most up to 80,000, and then you see schemes where the application is aggressively opposed and the costs now are starting to escalate in the 100,000s. So it definitely depends from scheme to scheme what the situation is, and this will definitely inform the cost of the application. But traditionally, if we receive an instruction to place the scheme under administration, we will require the deposit of the 25,000 Rand, and also depending on who's issuing the instruction for the scheme to be placed under administration. So if it's the board of trustees that are come together, and I've had this situation where the board of trustees are like, you know what, we don't know what to do anymore. The owners don't attend meetings. The owners are not making decisions. When we do make a decision in terms of the prescribed management rules on a reconvened AGM, it's complaints left, right, and center. So we don't know what to do as the board of trustees, and we're seeking the professionals to assist. So then they will take that cost, the deposit, from their administrative budget. So they will resolve as the trustees to say, we as the Board of Trustees for Sunshine Body Corporate are deciding to place the scheme under administration for these reasons. Then you also see singular owners or a group of owners that find themselves in situations where the scheme is not moving forward and there's non-compliance that is not being addressed, and they come together and they say, okay, this is how we're going to contribute to the 25,000 rand deposits, owner 1, 5,000 rand, owner 2, and then they give us that list, and then that's the situation we will credit the levy statement of the owner for the contribution that those group of owners have come together to bring the application. So that's the discussion with regards to the costs. You can move on to the next slide, Laura.
No, hold on. Before you run over to the next slide, I just want to also quickly have a chat about the cost. I mean, in respect of the scheme or a particular scheme, I don't actually want to go into specific details and say which scheme it is, but in respect of a specific scheme, which is also a fairly new developed scheme, where there are also problems with the developer, there are also structural problems in respect of that building, which amounts to about 30 million rand in respect of that scheme. And in that instance, the developer is fighting the administration around every corner because he does not want to actually comply with that obligation to fix the scheme. And that application, I'm aware, has cost hundreds of thousands of rands already. But the fight is about 30 or 40 million rand in respect of the repairs and maintenance that needs to be done to the scheme, which the developer doesn't want to do and is opposing the administration because he's trying to let owners at the end pay for that out of the levies and out of the maintenance fund and so forth. So definitely it can go up to hundreds of thousands of rands. In this matter, I know that senior counsel, you guys have employed senior counsel in respect of that matter. So it can be very expensive, but that's not a run-of-the-mill application. That is not the normal and the general thing. One would, in general, if you bring the application, you would start out with the deposit of 25,000 rand, and then the cost would not necessarily be much more than that at the end of the day if it's an unopposed application. But if it goes the opposed route, depending on the fight that is being fought, then it can go much higher. Lauren, I see that slide is still just showing a blue block. So, and then also the cost in respect of the administrator, maybe that's also something that you can touch on. How do you guys deal with that in your order?
Yeah.
How do you cost? Yeah. And does it form part of the budget, or is it excluded from the budget? How do you guys deal with that? Because I know that you guys are doing it differently from how other administrators are doing it.
So we see that most administrators in the industry are charging an hourly rate, or will charge like a flat rate to say 700 rand per hour or 8,000 rand per month, and that is not the methodology that we follow at Confiance. So traditionally, if we are providing the scheme with only the administration service part of it, so we are the ones that are doing the rehabilitation work, so solving the problems, and then there is a managing agent that will do the day-to-day of the scheme along with us. Our charge as the administrator will then be 250 rand per unit per month. Then the managing agent fee will also be whatever they charge, the 8,000 rand per month or whatsoever. Then if we are doing all of the work, so we are doing the managing agent work and the rehabilitation elements of the work, we will charge then 350 rand per unit per month. Now, for schemes that are less than 15 units, we then charge a flat rate of 8,500 rand. And the same principle will apply if there is a managing agent, if there isn't a managing agent. And we structure our remuneration within the order. And we request in the application that it be itemized separately on the levy statement. So traditionally, what you will see on our levy statements, you'll see administrative fund levy, reserve fund levy, maybe if there's a special levy, sewer, and then you'll see administration fee, which is the 350, pardon me. If we are doing all of the work, we are managing agent services and administration services, or it will be 250 Rand per unit per month if we are only doing the administration services. And I think that kind of sets us apart from the industry, from other administrators, to say that because if you're charging an hourly rate, how are you accounting to the owners what you are doing for the scheme? So we put our prowess in terms of the act, so what we are going to do, what we are able to do in terms of the sorry, the application, and we then remunerate ourselves in terms of what the court has ordered, the 250 per month or the 350 per month, or the flat rate of 8,500 Rand. Then if it is the flat rates of 8,500 Rand, if the units in the scheme are less than 8,500 Rand, we divide that by the PQ.
Okay. All right. I saw that there was also a question asked, and then maybe we can also deal with that under the big misconceptions, the difference between an administrator and an EMA. So an executive managing agent steps in the shoes of a trustee. So they only fulfill the duties that trustees should fulfill. When administrator steps in the shoes of owners and trustees, and as such makes all decisions and implement the decisions. So there's a far greater responsibility on an administrator than on an EMA to make sure that things are done in a correct way. So that is one of the differences. I also think that one of the other differences, obviously, is depending on who you appoint. There are administrators and there are administrators, and I think not only are you charging differently, also the way that you guys are doing things are differently, Veronica, to say that.
Yes, 100%. And just to add on what you've just said now, Willie, with the difference between an executive managing agent and an administrator. With an administrator, there's a fiduciary duty towards an administrator to make the decisions in the best interest of the scheme. And this is the same fiduciary duty that is extended or required from trustees in terms of Section 3 of the Sectional Title Schemes Management Act. So most importantly, the administrator and people tend to ask me this question, like, what's in it for you? What do you benefit? We benefit from executing our fiduciary duty in terms of rehabilitating the scheme. How does Confiance win? Confiance wins by turning the scheme around. And yes, admittedly, it doesn't happen in all schemes, but in most schemes, schemes are able to turn around. So with the administrator, the administrator steps into the shoes of the decision-making shoes of both of the trustees and the owners. So then the administrator will make all of the decisions, and the decision-making elements in your AGMs, your SGMs will then be frozen, and that will be assumed by the administrator. Another misconception that we see that owners tend to feel that they will lose control of the scheme, or they feel as if the administrator will sell their properties. This couldn't be further from the truth. Owners can't lose control because you are an owner in terms of the title deed or your sectional title deed in terms of the deeds office. So by granting of the administration application, the administrator can never be the owner of your units. The only thing that the administrator becomes is the decision-making power for the scheme. And in the same sentiment, the administrator cannot sell your properties because they are not the owner. In terms of legislation, a person who can sell a property is the person that owns the property and the sheriff, if the property is being sold to settle debt. And I think that's where the misconception is linked to, in the essence that as the administrator, we have a duty to now recover the arrears of the scheme. And how we do this is we issue a legal collection mechanism. Now, in terms of the legal collection mechanism, we will go to court, we will apply for a judgment. So we will follow the route, the summons route, we'll go to court, apply for a summons, we'll get a default judgment, we'll go to Rule 46, and Rule 46 means to sell the property in execution. Now, when the property is sold in execution, it is not the administrator that is selling the property in execution. It is the sheriff that's selling the property in execution to recover its outstanding levies. So there's just a difference there from an administrator now wanting to sell your unit or having the power to sell your unit, and the administrator collecting the arrears of the body corporate through the legal collection system, which lead up to the selling of the property in execution. So that is also one of the misconceptions that we see. People fear that their properties will be sold by the administrator, which is nothing further from the truth. No worries.
Right.
Yeah, we were just discussing the misconceptions of an administrator, or what people perceive an administrator to do.
Perfect.
And we see this mostly when it comes to the selling of those properties on execution, where people think the administrator now miraculously becomes the owner and sells the property, where that couldn't be further from the truth. And it's actually the effect of the legal collection process to sell the property in execution, rather than the administrator just willy-nilly selling people's properties.
I also saw somebody that made a comment that says this is going to lead to a lot of homelessness in South Africa. Can I just comment on that?
Yes, please.
So at the end of the day, people that stay in a community scheme have an obligation to contribute towards levies. And those people have to contribute, and that is just the type of ownership that they decided to be in. And for those owners to not pay their levies, and at the end cause a scheme to go into distress and then lose their properties, we need to decide on what side are we. Are we on the side of the people that are paying their levies, or are we on the side of people that are not paying the levies, that are actually causing everybody's properties to lose value, that they are not maintained, that they don't have water and electricity, and so forth. So we have an obligation to make payment, and people should start understanding that. And if you can't, then you have sufficient time to actually get through the process of selling your property and moving to something that you can afford. It might sound harsh, but that is the reality of property ownership. If you can't contribute, then you should not be there, because you are actually burdening the other people in the scheme and you're causing them damages. So we need to understand that. When we were asked to pitch regarding funding at the PIC at some stage a couple of years ago, when they assisted with funding for schemes that Stratafin has, I was asked the exact same question, and I answered the exact same thing at that stage as well. So it is not that one is heartless, but one needs to decide on which side of the coin you are. And people do have the opportunity to actually sell if they can't afford, and move to something that they can afford, because they are causing other people the distress and loss in value. I mean, we have seen properties. Sure.
Sorry, I always say this in our pitches, to say that community scheme living is Ubuntu living. So what you do independently as yourself, staying in unit number 5, affects the owner downstairs to you, affects the owner next to you. So if you are not paying your levies, but you are consuming the services of the body corporate, and you are enjoying the amenities of the body corporate, unit number 7 next to you, or unit number 3 downstairs, has in some way effect, will have to contribute for your lack of contribution, which is not fair, to say the least. We've had a scheme that we've been the administrator for close to 3 years now. We're actually at the end of our term, where we saw, when we came in as the administrator after a year or so, we launched a maintenance project where we attended to all of the urgent maintenance in the scheme. We did the painting, we fixed the roofs that were leaking, we painted the boundary walls, we attended to the stormwater sewage system, and we basically gave that scheme a facelift. Once again, I must say, the owners were paying their levies, so that's how we were able to fix the scheme. The administrator didn't get a blank check to fix the scheme, but the owners there were then able to sell their units. When we came in at the first meeting that we had three owners that say, no, they're not going to be able to afford the levies and the cost of the administrator, the additional 250 rand, by the way. So we want to sell. But in that year, when we were appointed, before we did the maintenance project, they were not able to sell their units. Immediately when we were done with the maintenance project, those units started selling. And now there are three other owners. I think the fourth one now is in the process of being transferred, where now the units are able to sell. Where they couldn't sell for 450,000 rand, now they're selling close to 1 million. So this scenario touches on a few concepts. It touches on the what Willie, you can't afford to stay somewhere. Unfortunately, you will need to move. And sorry if that is harsh. Secondly, the administrator is empowered by the payment of levies. If those owners were not paying their levies, that maintenance project wouldn't have been able to be done. And thirdly, the sale of those units was independently reliant on that maintenance project that we did. Because before we did that project, the owners couldn't sell their units for what they think was value for their units. It was selling less and owners were not able to part with that difference. So I think this example just illustrates the value of an administrator, also touching on what Willie said and what I said about the payment of levies actually contributing to the rehabilitation of the scheme.
Perfect. I saw that there was somebody that asked about the trustees link. The trustees training link is on the Stratafin portal. So if you click on the Stratafin website and you then go to the top, you will see that there is multimedia. I think it says under multimedia. Then there's a portal or a tab that says trustees training link. So that's free. So all you need to do is fill out your information there, and then you've got a 12-module course that you can actually go through. And it's open to all owners, and it's for free, so you don't have to pay for it, and it actually assists in respect of you learning a lot about the sectional title and your obligations and your rights in respect of that.
So I'll just take a question from the chat, which is the last question. I don't know if I'm lost or they are lost. There's a question that says, hi, in our complex, it seems like the previous trustees were not active nor have the knowledge to perform the duties of trustees. Now our municipal account is in massive arrears. Can action be taken against the previous trustees? So yeah, this is something that we see a lot of the times where the trustees are not knowledgeable on how to endeavor sectional title related issues. So the first recourse would be to go to CSOS. There isn't a jail, unfortunately, for trustees that fails their fiduciary duty, unless you are able to afford a civil action against trustees who failed to perform their civil duty, their fiduciary duty, pardon me. So there is recourse in the sense that you can go to CSOS and explain to them the issue, and but going to CSOS won't kind of give you a way forward. So a way forward here would be, yes, you need to have a new board of trustees that can prove that they're not, even if they are not knowledgeable on sectional title, but that are willing to learn or have some experience in some sort of management. So yes, CSOS will not give you a rehabilitation of the plan, but they will hold the trustees to account, which I think that is what you want. But for the success of the scheme, or for the way forward of the scheme, I think it would be best to get a plan of appointing a new board of trustees that will be able to handle the scheme. Okay, and then I'm just answering a few questions, Billy. I saw that the network dropped with you guys over there. There's another question that says, is there legislation that protects owners that are actually paying but are burdened by the non-payers? For an example, in my scheme, there are two owners that have been taken to court over years, but make arrangements, but still default on their arrangements. Now, this is what I mean with sectional title living is community scheme living, because now these owners that are not paying, you as the owners, the paying owners, need to pay their legal bills, which is not fair to say the least. What I can encourage the paying owners to do is to put pressure on the trustees to finalize the legal collections process, because that is the only way you'll have those owners go out of the scheme, is to have their property sold in execution. Then you have new buyers into the scheme, and hopefully buyers that are able to pay their levies. And yeah.
Can I just jump in there? The collection process on an undefended matter takes approximately 2 years. So if the matter is not defended and you start from issuing of summons and you go to up to sale in execution, that process, knowing the process, following the process, and actually doing everything on time will take approximately 2 years. That is just how long the courts now take to issue dates and to issue dates for applications and so forth. So if one do not take action immediately when people start getting into arrears, then you're going to have a problem. So we suggest that schemes, as soon as people start getting in arrears, take the matter to CISOS, get a order from CISOS that forces this person to pay. Eventually, you're going to use all those orders and you're going to make them orders of court, and you're going to then follow the court process. But immediately take action as trustees and as managing agents to actually do something about it, because the process does take a long period of time, and it places a huge burden on schemes if you've got lots of people that are not paying. When we started Stratafin 10 years ago, we saw in schemes a default rate between 5 to 7%. That is what we saw people are not paying. We're now seeing in schemes 25 to 35% of owners that are not paying. So there's a huge move towards people not paying, and they understand that the legal process takes so long, and they're actually exploiting it. So it's important that one takes action as soon as possible.
Yeah, I think the other questions that were in the chat. Yeah.
Now I see that people ask for slide 5, 6, and 7, but we're going to send all of this out. So
yes.
the recording
and
will also
answer
be available
all of the questions. Yeah, and we'll answer all of the questions as well, and we will send it all out. Unfortunately, there isn't time to go through every single question, but we will do that.
Yeah, sorry, Willie, just thanks, Veronica, for helping us out there when we lost signal. But I will send out the presentation with all those slides, as well as the copy of the recording.
Perfect.
Okay.
Thanks, guys.
Thank you, everybody. Thank you,
Really
Stratafin, for the
appreciate.
invite.
Really hope there was some valuable information shared.
Yes, yeah. We'll answer all of those questions and we'll send them through to you. Thank you, everybody.